In this video today, I want to talk to you about 4 different types of trust, as well as some of the misconceptions around trust and the uses of trust. And I think you'll find there is a lot of overlap among them, but there's also some very notable differences. So the first trust I want to talk to you about is something called a testamentary trust. So this is probably one of the most common, and it's created by your will. So it's made by your last will and testament, making it a testamentary trust. So the language to create this trust is included in your will, and it's created at the time of your passing. Now, a testamentary trust can include a lot of the same things in it that an other trust might have in it, such as maybe a kid can't get access to it until they're 35. Maybe it has spendthrift provisions. It just depends on how much control you want to have beyond the grave for these assets. One important thing to note about a testamentary trust is that it does not bypass probate. So, because it's created by the will, the assets pass through probate before they're placed into a testamentary trust. Now, one of the misconceptions that I hear a lot about trust is people say, well, I need a trust for creditor protection, or I want a trust to save taxes or estate taxes. And for most people, estate taxes isn't an issue today and maybe even in the future, because today the lifetime exemption for one individual is 13.61 million. There are some states that have what's called an inheritance tax, and that's going to be measured on a state by state basis. So the next trust I want to talk to you about is something called a living trust. So a living trust is probably one of the most common types of trusts that somebody creates in retirement because it's a way that you could bypass probate. So if you create a living trust, it's called a revocable living trust. You're the beneficiary, you're the trustee, you can put money in, you could take money out, you can change the trust. So it's completely revocable. You can change everything about it. However, at the end of your life, anything that's in the trust would then bypass probate. Essentially, if you're the trustee and you have named a successor trustee, that successor trustee and beneficiary would get access to that trust at the end of your life, right? So the successor trustee would take over as a successor trustee, and they could distribute the assets or make distributions to the beneficiaries at that time, and those assets wouldn't have to pass through the probate process. So a living trust, also referred to as an inter vivos trust, which essentially in Latin means among the living, is funded during your lifetime, right? So it's funded during your lifetime, and it's important to take into consideration that it must be funded for it to work. So if you've seen the video about estate planning mistakes of the rich and famous, Michael Jackson did not fund his living trust, and therefore none of his assets made it into the living trust. They all actually had to go through probate, which made for a much lengthier process in terms of the settlement of his estate. If you're able to put all of your assets into a living trust, it's very possible that very little of your estate could pass through probate. So many times when people have a living trust, their will is then referred to as a spillover will, right? Because in the will, it essentially says that anything that had not made it into my trust by now should spill over into the trust. So you have the trust, and then the will essentially says, put everything into the trust. So that's known as a spillover will. Depending on the state and depending on the advice of your estate attorney, you may not be able to put everything into the trust. Some states are weird about putting cars in a trust, especially transferring the title of a car into the trust. For a house, it can also potentially, and some professionals would advise you not to do it while you have a mortgage because it could potentially trigger a transfer of ownership clause. I've actually been told by clients that had rental properties, and the HOA had a line item in there that basically said you can't change the title, you can't change the ownership at all. And so they were blind to the fact that it wasn't really actually going to another person. it was only going into a living trust, but the HOA said, if you go into the living trust, you are going to lose your spot in line. Right now, they're able to rent the property, but if they moved it in the living trust, they would go to the back of the line. So they were essentially grandfathered in. They could wait, 20, 30 years before they get to the front of the line again, and be able to rent that property. So it would really defeat the whole purpose of owning that property in the first place. So look at the fine print of any of your mortgages, talk to your mortgage company. If you've paid it off, then you just do a quick deed transfer, and any estate attorney should be able to help you with that. You do a quick deed transfer into the trust, and then the house is in the name of your living trust. Now, if you own the house in joint name, right, it would also bypass probate, right? So if you own it in joint name, joint tenants with rights of survivorship, it would bypass probate at the time of the passing of the first spouse, and the surviving spouse would take ownership of that asset without going through probate. So that's one of the advantages of account titling, which we're not going to talk about in this video today, but in terms of a house, it could accomplish the same goal. The next trust I want to talk to you about is something called an irrevocable trust. So you remember we had a revocable living trust, and now we're going to talk about an irrevocable trust. So an irrevocable trust is different than a living trust. And so many times when people think about estate taxes, right, it's not a living trust that they're thinking about. It might actually be an irrevocable trust, because when you put money into an irrevocable trust, it is no longer in your estate. It's no longer in your estate. It's actually no longer technically your money in many cases. So, from a creditor protection standpoint, if somebody is looking at protecting that money from creditors, well, if they give that money away and it goes into an irrevocable trust for the benefit of the next generation, and of course, check with your estate attorney and CPA on any of these strategies. However, if you move money into an irrevocable trust, in many ways, it could add creditor protection because it's no longer your money, and it could also grow outside of your estate. So let's say you have $5 million that you move into an irrevocable trust. Well, you might use up $5 million of your lifetime exemption. If, however, when you pass away, let's say 20 years later, that 5 million is then worth 15, that 15 million is not included in your estate. So it is not considered included in your estate because it was an irrevocable trust. The trust was not in your estate. The trust didn't die. You died. That money is not considered part of your gross estate at that time. It was frozen, a technique called freezing the value of your estate. That 5 million was frozen when it was transferred into the trust, into the irrevocable trust. So those are a couple things to think about when you think about an irrevocable trust. But just remember that in many cases, if you put money into an irrevocable trust, it's not your money anymore. It is being given away for the benefit of the next generation. In some cases, it could be your spouse. But technically, that money is no longer yours. The last trust that I want to talk to you about today is something referred to as a special needs trust, or sometimes referred to as a supplemental needs trust. So a special needs trust should be executed typically by a special needs trust attorney. Sometimes they're referred to as elder care attorneys. However, the reason why there are attorneys that specialize in these types of trusts is because it's important that they have a good understanding of government programs, which could be very different state to state and program to program. So think about Medicaid, right? A a trust that is executed properly could provide for the lifetime care of an individual while still maintaining eligibility for certain programs such as Medicaid. Now, this type of trust could be a standalone trust. It could be incorporated into a living trust, and it could even be mentioned in a testamentary trust. It could be created as a testamentary trust. So there's some estate attorneys that specialize in special needs trusts that have told me that you can even have a supplemental needs trust provision in your will. And the reason why you might have that is that if for some reason two individuals were in a car accident, right? And the surviving individual was a minor and ended up having a disability coming out of that car accident. And maybe they were eligible for certain government programs because of that disability. Well, if they inherit a lot of money and it goes directly into their name at that point, then it could disqualify them for those programs. So they could be required to live and handle all of their care with that disability based off that inheritance, which could go through that money very quickly. And so the special needs trust provision or special needs trusts in general allow to protect the principal of those assets and of an inheritance and only allow for supplemental income while still maintaining eligibility for those government programs. I hope you found this video helpful today. If you did, please give it the thumbs up below and subscribe and be on the lookout for more videos from this channel. Thank you.